Aaron Clemens.
Yes.
On the record in the matter, the people of the state of Michigan versus Aaron Thomas Clemens. File number is 22-01128. FY, council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people. The Assistant Public Defender Sarah Donnelly on behalf of the defendant Aaron Clemens Jr., who is appearing by Zoom.
Today's a date that's set for a
Separate preliminary exam.
except for a preliminary examination, but I hear a plea sheet. So my understanding is that there is going to be a plea today. Is that correct?
Yes, Your Honor.
The plea sheet I have here is offer from the people for the defendant to plead guilty to count 2 and an added count 3 of use of a controlled substance contrary to Michigan Compiled Law 333.74042B. And that is a misdemeanor, maximum penalty 1 year and or $1,000 fines. The courts, I'm sorry, the people are going to dismiss the original count 1. Is that correct?
No, Your Honor. There's a new offer in this matter. I did just type a new plea sheet up and send it to the family.
I'll throw this one in the trash.
Sorry.
No problem. You can say the offer on the record.
Sure. The new offer, Your Honor, is for the defendant to plead guilty to an added count 3 of use of controlled substance contrary to MCL 333.74042B, which is a misdemeanor punishable by up to 1 year and or $1,000 fine. In exchange for that plea, the people would agree to dismiss the original counts 1 and 2, and we also have no objection to him being sentenced under 7411 if he qualifies.
Okay, Ms. Donnelly, is that the plea?
Yes, Your Honor.
Okay, Mr. Clemens, did you hear that offer?
Yes, ma'am.
Would you wish to accept that today?
I do.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Okay, you can put your hand down, sir. Mr. Clemens, you have the right to be represented by counsel, and you are represented by Ms. Donnelly from the Office of the Public Defender. You have the right to proceed to trial in this matter. You have the right to have jury trial. At the time of trial, you have the right then to have the prosecutor prove each element of the charge against you. They have to prove each element beyond a reasonable doubt. You have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used to prove or implicate your guilt. You have the right to question or cross-examine any witness the prosecution calls. And then you have the right to call your own witnesses or present evidence that you believe would further defense to the charge. In order to plead guilty to the added count 3 of use of a controlled substance, you would have to give up each of those rights today, sir. Do you understand that?
Correct.
You want to give those rights up, sir?
Yes, ma'am.
Okay. Is anybody making any promises to you to get you to waive your rights and plead guilty?
No, ma'am.
Has anybody threatened you at all to get you to waive your rights and plead guilty?
No, ma'am.
Are you pleading guilty because you believe you are guilty?
Yes.
You said yes?
Yes. Yes, ma'am.
Are you currently on probation or parole?
No, I am not.
Okay, you understand that a guilty plea can result in a conviction that you may need to report to your employer?
Yes.
Okay. You understand that a guilty plea could result in a conviction that may impact any immigration status you may be seeking?
Yes.
Okay, and you still want to waive your rights, understanding that?
Yes.
Okay, as to the added count 3 of use of a controlled substance, how do you plead?
Guilty.
On factual basis, please.
Thank you, Your Honor. Mr. Clemens, on April 30th of 2022, were you at or near 420 East Michigan Avenue in the city of Lansing, Ingham County, Michigan?
Yes.
And at that time, were you stopped by the Lansing Police Department?
Yes.
All right, and you, when they
arrested you and searched you, did they find alprazolam on your body?
Correct.
All right, and do you have a prescription for alprazolam?
I do not.
And had you been on or about recent that time been using the alprazolam?
I have.
All right, Your Honor, I have no further questions.
Any questions, Ms. Lacy?
No, Your Honor, the people are satisfied.
Okay, the court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing on July 8th, 2022 at 8:30 in the morning. Prior to sentencing, sir, you need to meet with probation. They can provide the court with a pre-sentence report and recommendation. You need to turn yourself into probation in person within the next 48 hours so that you can complete the questionnaire and they can schedule your interview, okay?
Yes, ma'am.
Do you have any questions?
Nope, I do not.
You're also going to need to undergo a substance abuse assessment, but the probation department will provide you some further information on that, okay?
Okay.
Any additional matters for the record?
Nothing further from the people.
No, Your Honor, thank you.
Okay, you're all set, sir.
Thank you.
You're welcome.
Okay.
Okay, good morning, Mr. Moss.
Good morning, Your Honor.
Which matter are you here on? Oh, bond.
Yes, Your Honor.
Okay. His brother called me, right?
Is that what it is?
Yeah.
What did you tell me? Awesome.
Put the step in the file without me signing it. Do you know? Put these steps in the file if I didn't sign them.
Oh, I this morning I put it on the thing.
I'm not gonna sign this step to adjourn. We have to do that on the record because he did not wait his 21 days. But when Ms. Lacy comes back, we can wait the 21 days.
My office is emailing one over to you momentarily, and it's not already received.
The waiver? Oh, okay, yeah, we didn't receive it, but we can just do it on the record. Oh, wait, I think I did wait this one. See, right? Mhm. I think I found good cause to adjourn. I have a note here. Huh? I have a note, I put good cause. I did adjourn it because he was gonna flee. I think he wanted more time to think. So we'll just adjourn the day outside instead. 27th at 9:30. May 27th at 9:30.
Yes, that works. Just want to make sure I heard right, saying 9:30.
Correct. Okay, where's Mr. Austin? We're on the record in the matter of the people of the state of Michigan versus Jason Bike. File number 22-00955. FY council appearance.
Morning, Your Honor, Andrea Lacey appearing on behalf of the people.
Morning, Your Honor. Jared Austin, appearing on behalf of Mr. Bike, present standing to my right.
Mr. Mike.
Thank you. Today's the date that was set for a preliminary examination. This matter was set for 8:30. It's 9:04. Are we ready to proceed?
Your Honor, at this time, the people are unable to proceed. It's my understanding that Miss Edwards is not present. And I have not seen Officer Foote, who was subpoenaed to testify here today and would have been able to testify victimless. So people are unable to proceed at this time.
Mr. Austin.
Thank you, Your Honor. At this time, I would be moving for dismissal, understanding, of course, dismissal was without prejudice.
So the request for dismissal without prejudice will be granted. That simply means that if the necessary witnesses re-engage with the prosecution, they want to move forward, the prosecution does have the right to reissue the charge against you, okay?
If you're gonna just for the record, there is a current and outstanding case against Mr. Bike as well for GBH and domestic violence. Based on the nature of these charges as well as his history, I'm gonna recommend my office that we reissue this case as well.
Okay. Do you have any questions at this time?
Yes. Because that case she's talking about didn't get issued to this one. It didn't even get brought up, and it was 16 months.
I can't explain. I don't know anything about the other case. Your attorney probably could look into that.
My bad, I just brought it up because she did.
Oh, okay. Well, she just wanted to make sure you were aware that there's a high likelihood that they will be reissuing this because she doesn't want you to leave here today thinking that you may not get another charge from this and then may have to post bond again. So she's just trying to make sure that you're aware and why you're aware. But Mr. Austin can advise you further off the record, try to answer any questions that you have. Do you have any questions for the court? Any additional matters for the record?
Nothing further from the people.
Nothing further on behalf of Mr. Bike, Your Honor. Thank you.
Thank you. You're all set.
Thank you, Judge.
You're welcome.
Thank you. Have a nice day.
You too.
See you later.
What is? Oh, okay.
I would think so.
Thank you. Okay. We are gonna run Cartelle.
I'm gonna double check the operator to make sure that everything is good to go, and then I will do that. Otherwise, I don't want to read it.
Does Green, is Ronald Green here?
In the first half.
Yeah.
Yeah. that's fine.
We know if Ronald Green is here?
No.
He's not here, or we don't know? Good morning, Mr. Williams. Oh, he didn't start his audio. Okay, I'm not sure what's going on here. I don't know if they know that they.
Back to the speaker, so I don't hang on.
Do we know what's going on with Paige or Slater?
Paige is the special prosecutor. I haven't seen that.
Is Slater on the, is Slater in custody?
Yes, downstairs, Mr. Palmer.
He's talking to them.
He went down there.
Okay, sounds good.
And then, yeah, Slater, I believe, is going to be a request for an adjournment. I think Mr. Palmer said he just got.
Yeah, I haven't, I think it's street is PCC. Paige, you said who's the prosecutor on that one?
So, actually, I believe Adam is here for that. I can go have him come in and see.
Good morning, Mr. Williams.
Good morning to you, Judge.
How are you, sir?
I'm fine. It's a beautiful day out today.
It is, but we just get to see it from the window.
Beautiful
We're in
landscape.
Court from outside is frowned upon, so we're doing it inside. When the prosecutor comes back, we can address your matter. I think
Fine, Your Honor.
you're here with Owen, is that correct?
Yes, Mary Owen.
Sounds good.
On page Judge, Adam is here for that. It's not only walking in the hallway.
Sounds good. Do we know what we're doing with Cartelle?
Oh, you're right here. Sorry. He thought you were in the hallway. I just repeated what he said. Sorry.
The other- it was the other Miss Donnelly.
In the hallway.
The other Miss Donnelly's talking to him. Do we know what we're doing with Cartelle?
Running.
We're gonna run the exam?
Yeah.
Okay, very good. And are you on Williams? I'm sorry, Owens, Mr. Williams is on the. so
I am on Owen.
We'll handle that so
Okay.
they can get out of here and then. We're on the record in the matter of the people of the state of Michigan versus Mary Owen, file number 22-01031, council appearance.
Morning, Your Honor. Andrea Lacy is hearing on behalf of the people.
Richard Williams on behalf of Mary Owen, Your Honor.
You, and are you Mary Owen?
Yes, ma'am.
Okay, thank you. Today's the date that was set for a preliminary examination. I have a note here that you are going to be screened for sobriety court. Is that correct?
Yes, ma'am.
Okay. And so because of that, we need to waive the 21 days timeline for your examination. So you have the right to have your preliminary examination within 21 days of your arraignment, but because you're going to be screened for a possible eligibility with the sobriety court, we have to waive that timeline so that you can see if you're eligible. If not, you'll have a date to have your exam at another time. So you're not waiving your right to exam, just the timeline. Is that your understanding?
Yes, ma'am.
Okay, anybody want to, I'm sorry, did anybody force you to want to waive the 21-day timeline?
No, ma'am.
Is anybody promising you anything to get you
No,
to
ma'am.
waive the 21-day timeline? Okay. I'm sorry? At least, we can do June 24th. Does June 24th at 9 a.m. work for you, Mr. Williams?
I'm writing it down, Your Honor. That's 6/24 at 9 a.m.
That's correct.
I'll make it happen, Your Honor.
Very good. Well, let's reset this matter till then. If that date doesn't work, you can contact my staff and we can find another date. But for now, that should be sufficient. Any additional matters for the record?
Nothing
just,
further from the people.
Nothing further here. Miss Lacy, it's nice to actually say hi to you face to face, kind of.
Thank you.
Almost face to face.
Almost.
All right, thank you, sir.
All right, thank you, Your Honor.
Have a good one. Mr. Palmer. Did you speak to Slater already? And you were just appointed on that one.
I was just appointed on that one yesterday, late yesterday afternoon, Judge, so I certainly don't have any discovery in the matter. I only know very limited.
Okay, I wonder if they can put him on Zoom for the Polycom.
Judge, if I may inquire, the only, I guess, unusual issue is he's on parole. He indicated to me that his parole agent was supposed to contact the court asking about a PR bond so that he could go to TRICAP. I'm just asking. Judge.
No, we can go on the record on this. That's why I wonder if they could put him on. Like he mentioned this, I must have arranged him or he came before me and mentioned this a couple days ago because I vaguely remember this.
That's right, Judge. I think that maybe he appeared, it sounds like to me from him at least, that he appeared for PCC last week
He did.
without counsel. I'm guessing maybe he mentioned something about that.
He did. He said that his parole officer, I believe, was on her way with an order for him to go to treatment. And I said, okay, well, when that order comes, then I want to see it.
Right. I understand, Judge. I'm just asking the question.
I don't know if the order made it there. I don't know who his parole officer is either. I do know he is on parole, so.
Right. He reports to me that his parole officer is Nancy Hamilton. I do know she is actually a parole officer because I've spoken to her on other matters, but obviously I haven't spoken to her about this.
No problem. You know, if you get in contact with her and you find out that they are trying to get him into TRICAP or some treatment, I'm on call this weekend. I'm available all weekend.
Understood. Thank you. I'm hoping to not be working this weekend, but maybe.
I'll be here.
That never actually happens.
Okay, do you think that they can put him on the
I
Polycom?
don't think.
Oh, you think it is, they will, okay. And then we're gonna run Cartelle, and then who else do we have in here? We have someone else in here?
This Jackson. Just check.
That's Austin's plan, correct? He's about to run Cartelle. Are we running Jackson as well?
I
Yeah.
believe that's the intent, Your Honor, yes.
Okay. We're on the record in the matter of the people of the state of Michigan versus Emile Moore, file number 22-00629 FY, council appearance.
Morning, Your Honor, Andrea Lacy is hearing on behalf of the people.
Thank you, Mr. Moore. you're here today. You're scheduled for a preliminary examination. However, when you were here back last week for your probable cause conference, your application was still pending. I informed you that there was additional information that the public defender's office needed in order to make a determination. My understanding is that you did not provide that information.
Yes, I did. I called him. He called me back Friday, but I was at Barry Allen to get my son fitted for a tuck. So the mom told me to call when I got back. They said call in 42 hours. I called him the next day, which was Saturday, left a message to let him know. Monday, I guess they denied it. I called him back, got a touch by Wednesday. I kept calling him, finally got a touch on Wednesday. She said, I'm putting it back to you. He said, oh, we needed just 3 more questions. And he said,
So you talked to them on this week, Wednesday, and they said they was resubmitting your app.
He said,
Can someone verify that for
he
me?
said, the only reason why I was denied, I said, but y'all called on Friday. I said, I had called Thursday, y'all called Friday. I said, then Saturday, 42 hours, that's Saturday. And the weekend, about you left a message. They told me.
42 hours is throwing me off a little bit there, but maybe 48 hours?
At 48, yeah,
Okay.
whatever. They said something like that of that nature. I said, well, I contacted him, left a message, said, it's Saturday. I said, but I'll contact you again on Monday. So I called him Monday, I called him Tuesday, then Wednesday, they got called, we got in touch with me, and they was like, oh, we couldn't deny because you didn't call for 42 hours. I said, we got called, I was at Mary Owen. My mom told me it's at the 5 o'clock. So I was told, so I called Saturday, left a message. I said, and I called Monday and Tuesday. I said, you get in touch with me today.
And you provided them the documents that they were looking for? Sir.
Your Honor, what I can say, what the file shows is that apparently we originally reached out to Mr. Moore on May the 6th, requesting some additional information. The last note in the file, I believe, was from 2 days ago on the 18th, saying that there was denial. There is the form in the file signed by Mr. Church, saying that they had not received the additional information that was requested, and therefore it is denied. That's all the information I can provide the court as to what I see in our file, Your Honor.
Okay, yeah, we have a sign. What we have signed is from the 17th, but you're saying you called on the 18th, so maybe it got crossed somehow. What I'll do is I'm going to find good cause to waive your 20 or adjourn your matter beyond the 21-day timeline so that you can resubmit your intake with the public defender's office, okay?
He said he was supposed to call me back yesterday.
Who's he? Did they give your name?
I want he's talking to whoever the guy was. He said he had to talk to the boss. He left me on hold. He's like, okay, we're gonna resubmit it. I didn't get these questions. I gave him all the information. And he said he's resubmitted. So I'll call you back tomorrow. He said to let you know what happened. That was yesterday.
Let me tell you what I do when I'm on a really important phone calls and I speak to people. I ask them what their name is and I write it down so that I can verify later that, no, I spoke to so-and-so and they said they were gonna put this back through. But nonetheless, this could be remedied. So are you resubmitting your paperwork today so we can make sure that it's gotten in? Because I'm not sure at this point, based on the notes that a public defender is telling me that he sees that information has been resubmitted. So you want to make sure it's submitted. So
I called to you already.
well, you don't, we have at least 3 public defenders sitting in here right now.
Who's the office at? I can go right down there too.
The office is on the street, but I don't know if they would prefer you to do that. Ms. Donnelly, do you know what the preference would be?
Our office is open, 8 to 5, except for 12 to 1.
Okay, well, you can get the address from her. They're down the street, but I don't know the exact address. And then you can go down there and confirm or make sure that's done if that's what you want to do today, okay?
Down here already.
Yeah, it's walking distance from here. So I'm gonna find the cost to adjourn this beyond the 21-day timeline and give you a new probable cause conference date and exam date, okay?
I still haven't seen that.
May 27th at 2. We don't have a slot open until the 17th, June 17th at 8:30. Okay, your new probable cause conference is gonna be May 27th at 2 p.m. and June 17th at what time? 8:30. At 8:30 will be your exam. We'll get you a copy of those notices and then Ms. Donnelly can give you the address to put on the back of the notice, so you can just walk right down there today, okay? Great, you're welcome. Any additional matters for the record, counsel?
Nothing for the people.
You're all set for today, sir. Okay, is this Mr. Slater?
Yes, ma'am.
We're on the record in the matter of the people of the state of Michigan versus Bradley Slater, file number 21-030777FY. Council appearance, please.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Robert Palmer of the Public Defender's Office appearing on behalf of Mr. Slater, who appears via Polycom from the Lansing City Lock.
Thank you. How are you, Mr. Palmer? I'm sorry. I meant to say hi, Mr. Slater. How are you, Mr. Slater?
I'm okay.
Okay, that's good. Today's the date. All right, Mr. Palmer, I'm glad that you're good too, but I already knew that. Today's the date that's set for a preliminary examination. Mr. Palmer, I believe you were just appointed
That's
on
correct.
this matter.
That's correct, Your Honor. I received the appointment about 3:30 yesterday. I'm a little bit familiar with Mr. Slater because I actually was the one who handled the arraignment. And then somewhere in between the arraignment and now, something happened, so it was not assigned to counsel. I'm not exactly sure what that was.
Okay,
Obviously, at this point, Judge, I don't have any discovery. I know very basic facts based on what Ms. Lacy has relayed to me and what I discussed with my client. Certainly not in a position to run through at this point.
okay, sounds good. Due to the fact that you were just appointed, I'm gonna find the cause to adjourn the timeline beyond 21 days, give you a new date. And we're gonna do Friday, May 27th at 9:30. Does that work?
Your Honor, if I can just check in the hall, and make sure see if maybe. Judge, my victim is actually not present still, because I knew it was going to be determined based on Mr. Palmer's recent appointment. I would ask that at least another week, so we can send those papers out.
Judge, May 27th should work for me. I'm actually scheduled to be before this court that morning anyway.
I think she needs another week though for the witnesses.
Oh,
Correct, yeah.
June 24th, at what time? At 8:30.
June 24th at 8:30 is far enough out that I certainly can make that, Judge.
Okay.
The only other thing, Judge, I know we had a little bit of a discussion off the record, but my client has requested that I address bond.
Make your bond motion.
Thank you, Your Honor. I've had an opportunity to speak with Mr. Slater. Mr. Slater is currently obviously in custody and is also on parole. It is my understanding, although I certainly don't have any documentation of this, it's my understanding that his parole agent, Nancy Hamilton, is trying to send him to TRICAP in Saginaw. It's Mr. Slater's belief that he would be going there for 3 months. Given that we've now set it out to the preliminary examination, essentially a month in this matter, and also that Mr. Slater is not, as I understand it, earning credit on this file because he's essentially on dead time because of the parole hold. I would ask that the court consider a personal recognizance bond for Mr. Slater. I don't think I need to do a full flight risk type analysis because even if this court PR bonds him, he's not going anywhere. In other words, he's not going to be released from custody other than to go to TRICAP, maybe, which is a lockdown facility. It's my understanding that Mr. Slater has some significant substance abuse issues. He certainly desires to get some treatment for that. I would ask that the court consider PR bonding him on this matter so that he could at least go to TRICAP He also appears to have a hold in Clinton County. And Judge, it's our hope and desire that he can at least get these things moving, start to clear up some of the things that he has so that he can move on.
Turner, he may.
You may.
People would object at this time to any type of PR bond or even reducing the bond. I understand that he is being held on parole, so that does give me some type of hope. However, when I spoke to the victim in this matter this morning, there is another case in which Mr. Slater allegedly used his brother's name for another incident, causing his brother to now have legal trouble, even though he's alleging it was Mr. Bradley Slater as opposed to him. He's trying to clear that up. So it does appear that while he is out in the public, while he may not be necessarily harming other people, he is very capable of destroying lives without doing that.
Okay, well, my concern with releasing him on his personal recognizance is that he's demonstrated that he will not return to court. He's listed as absconding on Otis from parole. So, and he's had at least one failure to appear on this matter. This matter has been open since 2021. I think we didn't arraign him until earlier this month. Nonetheless, should there be an order or some approval for him to go to TRICAP or treatment, the court will be happy to address any bond then, but right now, it doesn't sound like we know whether or not there is an actual order for him to participate in TRICAP. He's got a hold in another. It also sounds like he got a hold in another court anyway, so doesn't sound like he's going anywhere. So to the extent that that information is provided to you, Mr. Palmer, as an officer of the court, you can notify me or my court. I'll adjust the bond at that time and make it specific that he's only to be released directly into treatment. But right now, I don't have enough information to make that alteration to the file. Mr. Slater, you were saying
Yes,
something?
ma'am. Yes, I'm sorry to interrupt, Your Honor. Nancy Hamilton was supposed to contact you Monday morning. She said she was going to try to get a hold of your office and let you know that I was going to be going to TRICAP.
Okay, well, she hasn't gotten in contact with me yet or my office, but to your benefit, you have Mr. Palmer and he's pretty diligent, so he knows who, or at least he's familiar with the name of Miss Hamilton, so he can follow up. And if he gets information from her directly, that's all I need. I don't need to speak to her directly.
Okay.
Okay?
Will I have to come back? Will I have to come back before you, or will the bond just
No,
be?
we've addressed it on the record. We've addressed it on the record. If Mr. Palmer provides me with some other information, I'll adjust your bond in the file, okay?
Okay.
And that's correct, Judge. I've had contact with Ms. Hamilton on other matters. I'm familiar with her, so I will certainly reach out to her. I'll try to do that today and get the matter moving along.
Okay, excellent. Any additional matters for the record?
Nothing for the people.
Okay, you're all set for now, Mr. Slater.
Okay, thank you.
You're welcome. It's at 8:30.
8:30, thank you.
Okay, we ready on Jonathan Cartelle?
Yes, Your Honor.
Okay, we're on the record in the matter, the people of the state of Michigan versus Jonathan Cartelle, file number 22-01120, FY, council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Thank you, Your Honor. Good morning. Jared Osden appearing on behalf of Mr. Cartelle, with approaching council table.
Okay, how are you, Mr. Cartelle? Okay, I'm doing well. Today's the date that is set for preliminary examination, and my understanding is that we're ready to proceed, correct?
Yes, Your Honor.
Any preliminary matters?
Just to make the court aware, as I mentioned, the people are going to be proceeding their counsel at this time.
Okay, any preliminary matters?
No, Your Honor. Thank you.
Okay, you can call your first witness.
Thank you, Your Honor. For the first witness, we will call this again, Officer Christy Childs.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, sir.
Thank you. You can have a seat there, officer. And can you state your first and last name and spell them both?
My first name is Christy, Christie. And my last name is Childs, Chiles.
Okay, counsel, you can proceed.
Can you please state your occupation for the record
Police officer.
and which department do you work for?
Lansing Police.
I'm gonna ask you to keep your voice a little bit only because that fan is directly in my ear, so I'm having a hard time hearing you. How long have you been employed by Lansing?
3 years.
Officer Childs, I want to take you back to April 28th, 2022. Were you working in your capacity as a police officer on that date?
Yes.
And were you working for Lansing on that date?
Yes.
Okay. Were you working alone or with a partner?
With other officers.
Did you have another officer with you in your vehicle?
No.
Were you in a fully marked car on that date?
Yes.
And how were you dressed?
In full LPD road patrol.
Okay. On that date, were you called to the address of 1200 East Oakland Avenue?
Yes.
And is that located in the city of Lansing, County of Ingham?
Yes.
Okay. And what's located at that address, if you remember?
It's a moving company.
Okay. What prompted you to go to that location?
Someone called on behalf of Rebecca Jardine. Called and said that she had been assaulted.
Okay. Were you dispatched to that location?
Yes.
Okay. And when you got to that location, did you make contact with someone named Rebecca Jardine?
Yes.
Okay. And what did you observe about her at that time?
She had some injuries to her face.
And can you describe to me her demeanor, if you remember?
Yeah, she was definitely very upset and afraid.
Was she crying, if you remember?
Yeah, she was emotional.
And did you have an opportunity to speak with her?
I did.
Okay. And did she tell you what had happened to her to cause those injuries?
Yes.
Okay. And without getting into the details of what she had said to you, can you tell us the big gist of what she had said?
Yeah, so she said there was an argument that took place between her and Jonathan.
I don't object to hearsay.
Do you want to respond to these?
Your Honor, I'm not sure I phrased my question correctly, so I think that's what prompted that.
Objection sustained.
Thank you. I'll try to rephrase that. Trying to phrase it so that it makes sense. Did she tell you that she had been involved in an altercation of some fashion?
Yes.
Okay.
Objection, Lee.
Do you want to respond to the objection?
Your Honor, I'll rephrase it again.
Objection sustained.
Sorry. When you were speaking with Mr. Dean, did she tell you why she had requested assistance?
Yes.
Okay, and what, without giving us like the details of what she had said to you, but what was the basic reason that she had requested that assistance?
She was assaulted and shot at.
I'm objecting to hearsay again, Your Honor.
If I can respond, Your Honor. I am attempting to lay the foundation for the testimony to come in under MCL 768.27C. I have not asked for any information with regards to the specifics of that intent because, or the incident, because obviously we're not there yet.
Okay, sorry. Is your last question being offered for truth of the matter asserted? Or is that being offered for another reason?
It is being offered to establish the foundation, but also as well as to go to the victim's state of mind at the time, as well as the officer's state of mind and the belief or the reason that she is at that call.
I'm gonna overrule the objection. You can proceed.
Thank you. When she had indicated to you that she was involved in an assault, did she give you the name of the person who assaulted her?
Yes.
And what was the name that she provided to you?
Jonathan.
Okay. And did she disclose to you the nature of their relationship?
Yes.
And what did she disclose to you?
She said that they had been sexually active and that they were living together.
Okay. They were residing together, correct?
Yes.
Okay. Your Honor, now I believe at this time that I have in fact laid the proper foundation for the statements made by Mr. Dean to come in under MCL 768.27C.
Any objection to testimony under MCL 768.27C?
I'm sorry, Your Honor.
Any objection to the foundation?
I wouldn't object if they lay the foundation as far as the predicate domestic relationship. Based on that, there is of course other factors and other elements that goes along with that. I would reserve any objections on that, depending on what the testimony is, and reserve further argument for that.
Okay, very good. You can proceed under 27C. Objections has been reserved at this time.
Thank you. Now, Officer Childs, can you tell us a little what Ms. Jardine told you had occurred?
So she said that there was an argument about money that was owed. And Jonathan proceeded to punch her in the face several times. While that was happening, she fell to the ground and he continued punching and kicking her several times. She was trying to cover her face and she was being assaulted so badly that she defecated on herself. And then at some point, he made a threat to kill her and her child. And then after that, she was able to get up and go to the bathroom to clean herself up. Once she was in the bathroom, Jonathan came in and punched her in the face multiple times while she was sitting on the toilet. And he walked out and she got up to close the door behind him. And when she did that, he tried to come back in. And so like they were on opposite sides of the door. And so there's a crack in the door and she could see him take a handgun out of his waistband, and then he shot it through the door one time.
Okay. And was she able to describe this handgun to you, if you remember?
Yeah, she said it was a small black handgun.
And did she tell you the location of this assault, if you remember correct? If you remember?
1124 Cleveland Street.
Your Honor, I'm going to show what's been marked as People's Proposed Exhibits 1 through 5 to 10. And if I can approach witness.
Okay.
Officer Charles, I'm handing you what's been marked as People's Proposed Exhibits 1 through 5. Without telling us what's in those photos, you just take a look at them and see if you recognize them. Do you recognize those photographs? Okay, and how do you recognize those photographs?
I took them.
Okay, and can you tell us where you took them?
Yeah, so the pictures of the victim I took at 1200 East Oakland Street. All these pictures I took at 1200 East Oakland.
Okay, now, did you ask her about those injuries?
Yes.
Okay, and did you ask her if she had those, any of those injuries that are indicated in those photographs prior to this assault with Mr. Cartelle?
Yes.
Okay, and what did she indicate to you?
So the bruising on her eye, her black eye, was from a different incident involving him. But the goose egg on the top of her head and the scratch on her cheek and the injury from the bullet were all from today, or from the day of this incident.
So I'm gonna have you just walk through each picture. If you can just tell us what is depicted by each photo. We'll start with what's in photo number 1 or exhibit number 1.
So the first picture is of Rebecca's face. It's like a frontal view of Rebecca's face, and you can see the like the swollen mark on her forehead here. And then
Does that photograph also depict the black eye you said was from a previous incident?
yes.
Okay.
And then the second photo is like a little more slightly elevated, and you can still see the swollen forehead.
Okay.
And then the next picture is of the scratch on her cheek, on her left cheek.
Okay.
And the next picture is also another picture of the scratch on the left cheek.
Okay.
And then the last picture here is from the bullet, the injury from the bullet.
Okay. Now, you'd indicated that she had seen him produce a handgun from his waistband. And did you say that he had fired that firearm? Is that correct?
Correct.
Okay. Your Honor, I would ask that these exhibits be admitted as people's proposed exhibits 1 through 5.
Without objection.
1 through 5 are admitted.
And did she tell you about the injury that you said was sustained from the bullet? Did she tell you how that happened?
Yeah, so it happened when she was standing on the other side of the door in the bathroom.
Okay.
And he shot the gun.
And at any time were you able to go to 1124 Cleveland Street?
Yes.
And in fact, there was a search warrant, correct?
Correct.
And were you able to enter that residence?
Yes.
If you can, will you tell the court if it's a single-story home or an apartment building?
It's a home.
Okay. And while you were there, did you observe anything to be consistent with the story that Miss Jardine had told you?
Yes.
And what was that?
So in the bathroom floor, there was a
Okay, and based on your training and experience as an officer, that's what it appeared to be, correct?
Yes.
And was it the same size as it would be expected with a small handgun?
Yes.
Your Honor, I'm showing what's been marked as people's proposed exhibits 6, 7, and 8 to defense counsel. Officer Child, I'm handing you it to mark as people's proposed exhibits 6, 7, and 8. Will you please take a look at those and tell me if you recognize them as well? Okay, and how do you recognize those photographs? Okay. And were these taken the same day?
Yes.
Okay, and had you spoken, did you have an opportunity to speak to Ms. Jardine about the hole that you observed?
Not specifically about the
Okay. But the way that she described it to you, you did find it to be consistent, correct?
Correct.
Okay, can you please walk us through those photographs and tell us what's depicted in picture 6, 7, and 8?
So picture 6 is the bathroom door. Picture 7 is a hole in the floor of the bathroom. And then picture 8 is slightly more far away. Picture of the hole in the bathroom.
Okay, and you're saying that the picture 7 and 8 depict the hole that you believe was from the bullet?
Correct.
Okay, and you think that those pictures are a fair and accurate representation of what you saw on that date in that location, is that correct?
Yes.
Your Honor, I would ask that people's exhibits 6, 7, and 8 be entered into evidence at this time.
Any objection?
Without objection.
Okay, they are admitted.
Thank you, publish the court. Now, Officer Childs, at any time during your investigation of this call, did you have the ability to make any contact with the defendant?
No.
Okay. Were you able to use any of your tools available to law enforcement to pull up a photograph of the defendant? Okay. Now, how did you do that?
So his name and date of birth was provided in the original dispatch information. And using that, I was able to run him a name and pull up his driver's license photo.
Okay. And do you remember that photograph that you viewed?
Yes.
Okay. And are you able to recognize that person in the courtroom today?
Yeah.
Okay. Can you please point to that person and describe what he or she is wearing for?
A black suit.
And based on the photograph that you saw, this is the person you believe to be Jonathan Cartelle with the same birth date that the victim had given you, correct? Your Honor, I would ask that you let the record reflect that the witness has identified the defendant.
Any objections to identification?
Your Honor, may I briefly vote here on the issue of identification, please?
Yeah.
Morning, officer. Now, when you were speaking with Ms. Jardine, did she give you the full and complete name of the person that she was describing who did this assault against her?
I don't remember.
You don't recall if she gave a middle name or not?
I don't remember.
And she gave you the first name of Jonathan, correct?
I believe so. No.
And would you agree with me there's more than one way to spell Jonathan?
I would agree with that.
Did she specifically give you the particular name of this Jonathan that she was talking about? And did she spell out the last name completely for you?
I don't remember if she spelled it the last name.
And did she give you the date of birth?
Don't remember.
And the photograph that you looked at, do you remember approximately when that photograph would have been taken as it related to the incident? In other words, do you know if it was a year prior, 2 years, 3 years, or do you not know or remember?
I don't remember looking at the date of the photograph.
No further questions, Your Honor.
Any objection to identification?
Yes, Your Honor, I would object based on the testimony. It's not clear how much of the name is given to the officer or the complete date of birth. There's no way of fully knowing whether that was the same person Ms. Jardine was describing, the same person that she believes she's identifying in the courtroom today. I would object on that.
You want to respond to the objection?
Yes, Your Honor, the officer did just specify that the name and date of birth was given to dispatch. So while we don't know necessarily if she does not remember whether or not the victim spelled out the specifics or gave her the specific name, she did have access to that information being reported at the same time as being related to this incident. I didn't get into it, but there's also a description that was given to her by Ms. Jardine. I can get into that if Your Honor is not satisfied with the identification, but I believe I believe there's a sufficient basis for identification at this time.
I'd like you to provide the court with additional information about the description.
Okay. While talking to Ms. Jardine, Officer Childs, did she give you a description of Mr. Cartelle?
Yes.
And do you remember that description?
Yes.
And what was the description that you can remember?
Dark complexion, black male, approximately 5'8", heavy build, with short braids.
And did she also give you like identifying clothing that he was wearing?
Yes.
Okay. And he was not present at the location, correct?
Correct.
And the identifying information that you just gave, some of that is depicted in that photograph that you were able to view. Is that correct? Okay. And along with that photograph, does it give you like the height and weight of the person included? Okay. And did those things, based on what she had told you and the photograph you're doing, they appear to match?
Yes.
Okay. And those things that she identified to you, the photograph that you viewed did appear to match, and they all appear to match the person that you have identified as Mr. Cartelle. Is that correct?
Yes, and I will say that his full identification was placed into the call while I was en route to make contact with Rebecca.
Okay.
So dispatch has the ability to take, even if it's not like the full first name, last name, spelling, whatever, like we can see and call history too. So his information was placed in the call before I even got there.
Okay. So even if you hadn't gotten that information necessarily from Ms. Jardine specifically, you would have verified it with her prior to
Yes.
continuing, correct? Okay. And I believe that would be a sufficient basis for the identification.
Are you continuing your objection?
I continue my objection for the same reason stated.
Okay, the objection is overruled.
Thank you.
Identification is noted.
Officer Child, by any chance, when you ran the defendant in Lee, do you remember if he had a criminal history? You don't have to tell us what it is, but do you remember if he had a criminal history? Okay. Fair. And she had indicated to you, just to make sure that I'm clear, that he had a handgun in his waistband, correct?
Correct.
Okay. But this was inside of that residence, is that also correct? And did she indicate to you what happened after he had shot at the door? Did he remain in that residence? Or and did you ask her if she believed that he had a firearm with him at the time, or she knew?
I don't remember asking.
You indicated when you first made contact with her, you said that she was very afraid. Is that correct? And you mentioned that she had told you that she had been punched numerous times and then kicked while she was on the ground trying to defend herself. Is that correct? Okay. And then you also mentioned that he had threatened to shoot her. And that was prior to pulling out the gun. Is that correct? And then he did in fact, based on what she told you, shoot at her. Is that correct? Yes. Now, we see the photograph where the bullet hole was in the floor. That's in the bathroom. Is that correct? Yes. Did she tell you at all how far that was from her?
They were on opposite sides of the door.
Okay. And you
Both trying to close it.
Close enough where that photo number 5 depicts where there's a bullet, an injury from that bullet. Is that correct?
Yes.
And based on your training and experience as an officer, do you believe that was a ricochet wound?
Yes.
Okay. So in close enough proximity to do injury to her, correct? Yes. Also, based on your training and experience as an officer, the injuries that you observed her to have on her person, were they consistent with the statement that she gave you?
Yes.
And would you say that they would be consistent with other assaults that you've investigated?
Yes.
Okay. And when you left her, was she still very frightened?
Yes.
Okay. Your Honor, no further question.
Thank you. Cross-examination.
Sure, thank you. Morning again, officer. So I understand it from speaking with Miss Jardine, you said that her and Mr. Cartelle had an intimate relationship. Is that correct?
Yes.
And they were living together? And they were living together there at that place that you responded to. Is that your understanding? And talked about the statements that Miss Jardine made that Mr. Cartelle had repeatedly struck her about her face. Is that correct? And he was using his hands when he did this. Is that right?
Right.
And she indicated that he was using a closed fist for these multiple blows. Is that correct? And you had an opportunity to observe Miss Jardine and her physical stature. Would that be a fair statement?
Yes.
And you said she gave you a description of Mr. Cartelle, a physical statement, or a physical description rather. Yes. And you would agree with me that Mr. Cartelle is larger in physical stature than Ms. Jardine, is that correct?
Can you speak up, please? I couldn't hear you.
That was a yes, is that correct?
Yes.
Thank you.
And Mr. Cartelle weighed more than Ms. Jardine. Would that be true?
Yes.
And based on your observances, you would weigh considerable more. Would that be a fair statement?
Yes.
And when you viewed Ms. Jardine, she didn't have, for example, she didn't have multiple black eyes on her, did she? And I believe you had indicated that based on what she had told you, at least one of the injuries that you were describing seeing, she said, was from an incident that didn't even occur that day. Is that correct? And she was not bleeding profusely from the nose when you observed her, was she? And Ms. Jardine had indicated to you that at one point, Mr. Cartelle had fired a gun at some point, is that correct? And that was at the bathroom door that we saw in the photograph earlier, is that correct?
Through the bathroom. Yes.
Okay. Through the bathroom door? And that photograph depicts some type of hole at the bottom of that bathroom door, is that correct?
Correct.
And as an officer, you've been able to observe, bullet holes before, is that true? On more than one occasion? And the hole that you saw at the bottom of that door was not consistent with a bullet hole from a small handgun, was it?
Correct.
As a matter of fact, you made note of that in your report, that could not have been a hole caused by a small handgun, correct?
Correct.
And so if Ms. Jardine said that Mr. Cartelle shot through the door with that gun, that would be something inconsistent with what she told you. Is that true?
Yes, but there could have been other things that happened before, after.
That's not what I'm asking. The hole that you observed in the door, you agreed was not caused by a small handgun, correct?
The large one would not have been caused by a small bullet.
And if Ms. Jardine said that Mr. Cartelle shot through that door, based on what you observed, that would have been inconsistent with that particular statement, true?
Not necessarily.
Well, if she said he shot through the door with that handgun, and you agreed with me that that hole was not caused by a small handgun, that's an inconsistency, true? Okay. And what you saw in Ms. Jardine that you believe may have been caused by some type of ricochet, would I be correct in describing that as a rather superficial injury? And you did not recover any type of handgun on scene in that house, did you?
I did.
And did she give any further description about the handgun? For example, did she specify whether it's a semi-automatic or a revolver?
I don't recall it specifying.
Is that something that you would have asked? In doing an investigation like this, is that something you would routinely ask somebody a question like that? And you also had an opportunity to look around and search through the residence, is that true? And you did not recover any type of shell casings in there, is that correct?
Correct.
You did not recover any type of bullet fragments, is that correct?
Correct.
And if you would have found either one of those things, you would have mentioned in your report, correct? And you said you observed some holes, I believe, on the floor that you said may have been consistent with something. Gotcha, is that correct?
Was in the bathroom floor, that would have been consistent with it.
And just from looking at that, you can't tell how long that hole was there. Is that correct?
Right.
In other words, you couldn't tell us if that was there for minutes, hours, days, or months, just from observing it with you. And you had not been inside that residence prior to that day, is that correct?
That's correct.
One much, Your Honor.
Okay.
Thank you, officer. It's all the questions I have.
I just have a couple clarifying questions. You responded to an address on Oakland, but the incident took place at the Cleveland Street address. Is that accurate?
Yeah, it happened in the address on Cleveland, and then she ran away. She doesn't have a phone, so she needed to go somewhere where she could call for help.
Okay, and so she said she was living at the Cleveland Street address with the person she identified as Mr. Jonathan Cartelle.
Yes.
Okay, do you recall at all if the information you pulled up in Lane, did that give an address for Mr. Cartelle at Cleveland?
I don't remember the address that came back on his driver's license information.
Okay. Any redirect?
Yes, sir, just briefly. Officer Childs, I'm gonna go back to that hole in the door. When you observed that hole in the door, did you observe any debris on the ground with regards to that hole? Okay. See, so in line with the questions, you can't tell us if that hole was there previously or if it was brand new, is that correct?
Right.
Okay, so we know it's not consistent with the bullet hole, but what did you, if you remember what the size of it was consistent with, what did you think it was consistent with?
The hole in the door?
Yeah.
Somebody could have kicked in the door.
Okay. Now, I can't tell from the pictures, and I'm not an expert in any way, but since you were able to observe it in real time, would you say that it would have been possible to shoot through the hole in the door?
Yes.
Objection, Your Honor. I think it calls for speculation.
Did you want to respond?
I mean, I can clarify it with her training and experience and crime scenes and training. If she can say that it would be possible to shoot through a hole, if that would make it better, but I think that
The question was based or seeing the hole, which is evidenced here in Exhibit 6, if she believed it was possible to shoot through the hole. Is that what your question?
Yeah.
You said that caused for speculation. That's just common sense. We have a picture of the hole, so I'm gonna overrule the objection.
Thank you. And you did search for casings and an actual bullet, correct?
Correct.
Now, based on your training and experience as an officer, do you always find bullets or casings at crime scenes?
No, to find the bullet, we would have had to take a first and tear up the bullet.
Okay. And based on your training and experience as an officer, is there always shell casings at a scene?
No.
No further questions?
May this officer be excused?
Yes, Your Honor.
Okay, thank you, Officer Charles. You can call your next witness.
Your Honor, I have no further witnesses. I do, however, have a certified conviction of jail sentence for Mr. Cartelle. It's been marked as People's Proposed Exhibit number 9. I'd ask that that be entered into evidence as People's Exhibit number 9.
Thank you. Okay, I do have here a certified judgment of sentence. There is a rate sale indicated that was certified on May 19, 2022. Any objection to the certification?
Your Honor, the law is pretty clear that comes in for the purposes of this hearing, so no objection.
Thank you. And People's Exhibit 9 is admitted. Any further proofs from the people?
No, Your Honor.
Thank you. And Mr. Austin, are you calling any witnesses today?
We'll rely on the evidence. Your Honor. Thank you.
Thank you. Proceed to argument.
Your Honor, as it stands, Mr. Cartelle is charged with 3 counts, 1 being assault with intent to do great bodily harm, less than murder or by strangulation. I would indicate to the court that the number of times that Mr. Cartelle had punched Miss Jardine, which caused her to end up on the floor trying to protect herself, and at which point he continued to punch her and then started kicking her, would certainly rise to the level of assault with intent to great bodily harm. He had no concern for her person at that time. He was, from what it sounds like, was trying to do as much damage and scare her as much as possible. The testimony was that he had been carrying a handgun on his person and then subsequently left the residence. Of course, that weapon was concealed in his pocket. We don't know whether or not he took it with him at the time or after he left the residence. More than likely that he did, since none was found in the residence when the officers were able to execute the search warrant on that residence. Obviously, Your Honor is now in receipt of a certified conviction showing that whatever the status of that weapon was at the time that he was in possession of it and shot inside the residence, Mr. Cartelle was not eligible to possess any type of handgun based on that previous conviction. And Your Honor, this time I'm actually going to ask that the court add an added count 4 of weapons, firearms discharge in or at a building causing injury. That is contrary to MCL 750-234B3. The statute itself, as well as the criminal jury instructions, do not indicate that a specific level of injury is necessary for this to be charged. And I would argue to the court that the wound inflicted upon Ms. Jardine, as indicated by the officer, that would be consistent with a being grazed by a bullet, certainly rises to the level of injury that would not have been there had she not been hit by an object launched in her direction by the defendant. However, if Your Honor is not in charge or inclined to do that, I still think that the weapons, firearms discharge in or at a building, contrary to 750-234B, would be appropriate as well. So I would ask that either the discharge in or at a building causing injury or just the discharge in or at a building be added as well. I think this was a very harrowing experience on behalf of the victim. Terrifying to have somebody in your home that you are in some type of relationship with, we live together, threatens to not only shoot you, but then in fact does shoot in your direction. Luckily, this is not an incident where he shot her directly. He was in very close proximity to her person, and this is not a more serious crime where she now ceased or anything. But I definitely think that all of the elements for each charge here would be warranted and within regards and including an additional count 4. So I'd ask that he be bound over on 4 counts of circuit court, Your Honor.
Thank you, Mr. Austin.
Thank you, Your Honor. For her testimony today from only one witness, that was a witness that was not an eyewitness to anything that did or did not occur during this alleged incident. The officer is merely repeating what Ms. Jardine said to her, as well as she testified about some of the things that she observed. The statements that Ms. Jardine made were admissible to this court under the appropriate statute. However, one of the key components of that statute is the court still has to make some type of determination as to the trustworthiness and the reliability of those statements. And I believe, based on the testimony that we heard today, Your Honor, that what Ms. Jardine stated certainly cannot be construed as anything that would indicate trustworthiness or reliability. The officer did not dispute that the person that she was describing who committed this assault against her, Mr. Cartelle, who was repeatedly striking her on or about her face, repeatedly hitting her with closed fists. And the officer did not dispute that Mr. Cartelle was considerably larger in stature and weight than that of Ms. Jardine. What Ms. Jardine said was true and actually took place. Don't have to be medical experts to know that I think the injuries that would have been reflected on Ms. Jardine would have been far more severe than the ones that were depicted in the photographs and the ones that were observed by Officer Childs. Especially considering that Ms. Jardine stated that one of those injuries on there did not even occur on this particular case. I think if what she's saying is accurate, you're going to see something along the level of bloody nose, multiple bruises, perhaps some type of broken bones to the face, and we don't see or have that anywhere here. As it relates to the firearm, the discharge, and shooting, again, Your Honor, the evidence is, I think, very, very circumspect at best. What Officer Childs agreed with me would be considered a superficial injury, which is what Ms. Jardine was reporting to be some type of an injury from a ricochet bullet, rather de minimis, that I would argue the court is not an indication of some type of ricochet bullet, particularly when there is not the type of evidence that we would expect to see if there were shots fired in that house. We can't be certain whether or not the whole floor that the officer observed was from a bullet hole. I suppose that could be argued that that's a question of fact for a jury to determine. However, there's really nothing else to corroborate or substantiate that, because our common sense would tell us there would be some type of bullet casings there would be some type of bullet fragments there somewhere. They can't just disappear. They can't just vanish. And I guarantee you they would be arguing, if they did find something like that, that supports what it is they're claiming occurred. And now they're essentially trying to argue, or I anticipate argue, that the absence of that evidence supports Ms. Jardine's story as well. That is a further indication, Your Honor, of the untrustworthiness and the unreliability of those statements. It just could not have occurred. And if what they're saying is true about the hole in the door, essentially what they're saying is someone kicked in the door, and if Mr. Cartelle fired at that door, it just so serendipitously happened to go through a hole in the door that was already there, I guess, and apparently vanishing in the thin air and leaving no trace behind. So I would ask the court to deny bind over on the charge counts for those reasons, Your Honor, and for the added count people were requesting. And also, Your Honor, from a purely legal argument as it relates to the carrying of a concealed weapon charge, Your Honor, he's charged with carrying a concealed weapon on his person. And I think the statute is very clear on that, Your Honor. 750.227 is that there is an exception if the person is carrying a concealed on or about his person in their dwelling house. The testimony that we heard today from Officer Childs based on what Ms. Jardine told her, is that Mr. Cartelle was living there. That would make that his dwelling house. Therefore, even if he was, or if the court believes that there is reason to believe that he was carrying a concealed weapon on or about his person in there, it would be in his dwelling house. And as a matter of law, that would not be a particular violation of that statute. There was no evidence or testimony presented that contradicted that Mr. Cartelle may have been living there. So I would ask the court to deny the bind over on that count as well, in addition to the other reasons I said. Thank you.
Today was the date that was set for preliminary examination. At the examination stage, the burden is on the prosecution. Their burden is to provide the court with sufficient probable cause that a crime was committed, and sufficient probable cause that you, the defendant, committed a crime. This is not a burden that should be confused with the burden for trial. At trial, the burden is then on the prosecution to prove each element of the charge beyond a reasonable doubt. It's a much more substantial burden. This is a burden that requires just that of more than mere suspicion that a crime was committed. We had testimony today from Officer Christy Childs that was listed under MCL 76827C in the absence of the alleged victim here. She testified that on April 28, 2022, she reported to a call to the area of 1200 East Oakland Avenue, City of Lansing, Ingham County. She said that someone called on behalf of the alleged victim, indicating that the alleged victim had been assaulted. She later determined the assault took place at the area of 1124 Cleveland Street, also in the City of Lansing, Ingham County. She was informed by the victim that she had been in some kind of sexual relationship with the individual by the name of Jonathan Cartelle, that they were living together at the time, that he was upset about some money, and that ignited a argument. He punched her in the face several times. She fell to the ground. She was kicked in her face, causing her to defecate on herself. He threatened to kill her and her child. She went to the bathroom to clean herself up. And it came and allegedly continued the assault. And then he retrieved a small handgun from his waistband, shot a bullet through the bathroom door. The officer testified that at the time that she made contact with Ms. Jardine, that Ms. Jardine appeared upset, she was emotional, she was afraid, she was crying, that she had injuries to her face. I have what people have admitted as exhibits 1 through 5. They show a picture of a person that the officer identified as Ms. Jardine on the date and time in question. I see what appears to be a possible black eye on the one eye. There seems to be a bruise to her forehead and a knot on her forehead as well. There's a bruise on the side of the face, dark red in color. You know, there's been some indication that some of the injuries or one of the injuries did not occur at this time. It's unclear to the court which one of these injuries that would be. There's also a picture of a bruise to a leg. I think that's the testimony and the circumstances. We have a alleged victim who reports to an address that she doesn't live, based on information we have, and that she has someone else to have to call the police. And she reports to the police at the time. The police were able to observe her in a manner where she's upset, afraid, emotional. She has some injuries that are visible. We're not doctors, neither is the law enforcement. I don't know if there's any broken bones here. I will indicate that in exhibits 1 and 2, the alleged victim's mouth does seem to be slumped on one side. But again, I'm not a medical professional. I don't know if that's an indication of some internal damage. And there's been no medical records. But there is sufficient information or evidence here based on these pictures and the testimony to believe that there was some injury that occurred contemporaneously to the call, and that I believe the court finds that that information is trustworthy and reliable based on these circumstances. Now, the defense made a argument about the prosecution's request to add a count. I'm sorry. Let's address the carrying concealed. The defense made an argument about the statute requiring a concealed weapon being carried inside of the person's own dwelling place. There was at one point, at least, the court was unclear as to whether or not you were objecting to identification. I think you continued your objection, but the court is to rely on that argument, and the court will have to understand that you're conceding that that was his address, which is also the address in which the incident occurred. And so, the court had already made a ruling that they found the identification to be sufficient, and that was based on the description that was provided of the alleged defendant, as well as the information that was called out over to the dispatch, which included the name and the date of birth. And so the court is satisfied that there was proper identification. As to carrying concealed, we did have testimony from the officer that the alleged victim stated that she could see through the crack, or somehow in the crack through the bathroom door, that the defendant retrieved a handgun or a small handgun from his waistband and shot through the door. I think at this point, although the court is satisfied as to identification, I would question the fact as to whether or not this is his house or whether he resides there is going to be reserved for the trier of fact. So I believe that there's sufficient probable cause based on the testimony to bind over as to count one and count two, if I wasn't clear as to count one, based on the testimony evidence presented today. As to count three, weapons, firearms, felon in possession, we have a certified judgment here indicating that the defendant was not or would not have been eligible to carry a firearm at the time of the alleged incident. The people are requesting to add a count four, weapons, firearm, discharge at the building. I don't recall hearing there being much argument during your closing arguments, but I did take note to the defense's concerns or objections as to speculation about the ability to shoot a firearm through the door, and that the defense did argue that there was a concern about the credibility based on the hole in the wall and the lack of the ability to find some fragments or bullet fragments or bullet shell casings at this scene. There's a hole here in the pictured in Exhibit 6 on the bottom portion of the door. The officer was clear that that's not a hole that would have been created by a bullet. But I don't believe that the testimony was that that hole came from a bullet. It's just that there was a hole and that the defendant shot through the door. And so, based on that testimony, I think it's reasonable to presume that it's possible that the defendant shot through that hole. The bullet, or what was identified as a bullet hole in people's Exhibit 7 and 8 are on the floor. There was testimony that there wasn't any fragments or casings recovered, but there was also testimony that the officer would have needed to pull up the floor in order to find any additional evidence, and that it's common that they don't always recover casings or fragments following a shooting. I think that this photo does depict or cause the court to believe that that was caused by a bullet hole. And so the request to add a count for discharge the firearm at a building, is that what the one you requested?
It's in or at a building, yes.
And the argument made by the prosecution was that the bullet grazed or somehow caused injury to the alleged victim. I will grant the request to add count for that will also be bound over to the circuit court. The bind over date on each count 1 through 4 will be June 1st. You do not need to appear in court on June 1st. That's the date they get the file from this court, unless your attorney provides reason to the circuit court as to why you need to have an additional arraignment. Your arraignment in circuit court will be waived. Your next court date will be a pretrial in circuit court. Mr. Austin will be made aware of that date. He'll make you aware of that date. Okay, sir? Do you have any questions? Additional matters for the record.
Nothing further.
Nothing further, Your Honor. Thank you.
Thank you. Bond was set at 10,000 cash surety. That will continue. We're off the record.
Thank you, Judge.
You can, your exhibits. On the record in the matter of the people of the state of Michigan versus Katina Jackson, file number 22-00484 FY, council appearance.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Ms. Jackson. She's present with me at the council table.
Thank you. Today was a date that was set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Okay, any preliminary matters?
None for the people.
No, Your Honor. Thank you.
Okay, you can call your first witness.
Your Honor, the first witness the people will call to stand Ms. Tasia, I'm gonna pronounce it wrong, but Tasia Kirkpatrick. Right here, and then we should just raise her hand.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you, ma'am. You can have a seat there. So ma'am, there's a microphone in front of you. I have a court reporter sitting behind you. Just to take down everything that's being stated here today. And so your responses must be verbal. They must be clear and loud so that we can hear you, okay? You can't remove your mask during your
Okay.
testimony. And then also, if there is a question that calls for a yes or no answer, you want to be careful to say yes or no, no mhm and uhs, or shakes and head nods, because we can't write that into the record, okay? Then lastly, if there's an objection and you are given an answer, you will stop your response. I'll make a ruling, then I'll tell you if you can get that answer, okay?
Okay.
Okay, please state your first and last name and spell them both.
Tiana Kirkpatrick. Spelling?
Yes, please.
CAHJAKIRKPATRIC.
Proceed, counsel.
Thank you. Ms. Kirkpatrick, I'm gonna take you back to the date of January 22nd and January 23rd of 2022. Do you remember those dates?
Yes.
And on those dates, were you present in the area of 441 East Edgewood, apartment A?
Yes.
And is that in the city of Lansing, county of Ingham?
Yes.
Okay. And did something happen on those dates that brings you to court today?
Yes.
Okay. And can you walk me through a little bit of what happened? And I'll interrupt you, but start talking about what happened that brings you to court today.
Me and Ms. Jackson got into an altercation. She was at my house.
Let me stop you there. You indicated that there's a Miss Jackson
Yeah.
that you got into an altercation with. Is that correct?
Yeah.
And is that person present in the courtroom today?
Yes.
Can you please point to that person and describe an article that they're wearing for the court?
She's right there. She has on a black t-shirt.
Your Honor, please let the record reflect that the witness has identified the defendant.
Any objection?
Without objection.
So noted.
And can you, before we start talking more about the that, can you tell me what the relationship, if any, you have with Miss Jackson?
She's just a friend. She's considered like a god sister, but we don't have any blood relation.
Okay. And you indicated that you got into an altercation with her, is that correct?
Yeah.
Okay, how did that altercation begin?
We were drinking and we had a disagreement about something. I couldn't recall what the disagreement started about.
Okay.
And it escalated to the point of, physicality.
Okay.
She was hitting me, biting me. I tried to fight her back, you know what I mean?
Okay.
So, but to get her off of me. And as I said, I was getting ready to try to call the police. She took my phone. She left with my phone, so I couldn't call the police.
Okay, let me back up here. When you guys started this physical altercation, who was the first person to lay hands on others? Okay, and do you remember where it was on your body that she touched you first?
My arm.
Okay, and do you remember if she punched you, slapped you, or?
Do I remember where?
If
it was just, when you get to a fight,
all over.
all of it.
Okay, and approximately how long did this physical fight take place, if you remember?
Maybe 5 or 10 minutes before my neighbors called the police because they heard the argument.
Okay. And you said at some point it stopped, correct?
Yeah.
And you had indicated that you were going to call the police?
Yes, my neighbors actually heard it and they were the ones that called the police.
But you, at some point, did you say
Yes.
out loud that you were gonna call the
Yes.
police? Okay, and was
Yeah.
that in Miss Jackson's presence?
Yes, it was.
And the residence that we described, the apartment, is that your apartment?
Yes,
Okay, and does anyone live there with you?
me and my son.
Okay. And was your son present during this
No,
altercation?
he wasn't.
Okay. You would indicate you were drinking, so. all
Yes,
right.
no, he wasn't there.
And was this at nighttime?
It started during the day
And
and escalated to the next day.
so you indicate you're gonna call the police, and then what happens after that? I'm sorry.
She proceeds to try to take my phone and
Okay,
does, she does take my phone.
okay,
She's taken it on more than one occasion.
okay. And what happened after she took your phone?
I had to go to the party store to get a hold of, a friend of mine to get a hold of her to get my phone back.
Okay. And so at this point, she had left that
She had
location.
left.
Okay. And you indicated that this
Yeah.
argument continued to the next day,
Yes,
is that
because-
correct?
Yes, and then the police remove her and then they let her go and she comes back.
Okay. So maybe, yeah, police respond to your
They
residence?
respond to the residents.
Okay.
They remove her. She ends up coming back to the apartment
Okay,
and that's when it follows and flows into the next.
let me back up just a little bit. When the police arrived, had she returned to your residence?
No, this is the first time that they came.
Okay,
And then they were called back.
I'm gonna back you up, 'cause the timeline's a little bit confused.
Okay.
So you just indicated that she had left. Is this the?
She did leave with the phone.
Okay, and then were the police called after that incident, or were they called prior to that incident?
Prior.
Prior, okay. Was there a separate incident prior to the assault
No.
you just talked about?
No.
Okay. So let's talk about it. Police are called to your residence prior to this altercation, correct? Okay, and were they there for her or somebody else? Okay, and you said that she was removed, so she asked to leave the
No,
premises?
the police removed her from my house.
Okay.
When I told them that the police told me that.
Hold on
Objection,
one
Your Honor,
second.
non-responsive.
Okay. Objection sustained. You
I
can
got
only answer questions that are asked, okay? No problem.
So let me make sure that I have all this correct. So they respond to the location for her, remove her from your house, and at some point she comes back.
Is that a yes?
Yes, sorry, yes.
And is this all taking place on the 22nd or 23rd of January? Okay. And was there an altercation between the two of you prior to the police being called?
That day,
Yes. What I'm trying to get at here is why they were there to remove her.
because she was trashing my apartment and she bit me and she fought me.
Okay.
She tried to stab me.
All right, let's talk about that a little bit. It sounds like you said that she had trashed your apartment. Is that correct? Do you remember what date that was?
Third,
And was there also a physical altercation that took place on that day?
bruises.
And at some point you indicated that she had tried to stab you, is that correct?
Yes, yeah.
Okay. Can you tell us what happened leading up to that?
We were fighting. I was running from her in the apartment, trying to get away from her. I locked myself in my bathroom and she had the knife trying to break down the door to get in there with the knife.
Okay.
I don't have the pictures or anything, but my office people do
Okay.
with all the damages.
So let me back up. So she has a knife. Are you able to see the knife at this point?
Yes, I'm running up the stairs to my bathroom. I locked myself in the bathroom.
Okay. And can you describe the knife that she had had?
It was like long, it was kind of like a turkey carving knife.
So a kitchen knife.
It was a kitchen knife, but it wasn't like a butcher knife. It was like a carving knife.
Fair. Was that taken from your kitchen?
By the police?
No. Yes.
From my kitchen set?
Yeah.
Yes.
And while she has this knife in hand, is she saying anything to you?
Yeah, I'm gonna kill you.
Okay. And when she's chasing you and says, "I'm gonna kill you," how are you feeling at that point?
I'm scared, for my safety, for my well-being, for my neighbors.
And were you afraid that she could actually harm you with that knife?
Yes, ma'am.
Were you able to get yourself in that bathroom?
Was I able to get in the bathroom?
Yeah.
Yes,
And-
I was able to lock the door and get myself in the bathroom so she couldn't harm me.
Okay. And what happened once you were inside the bathroom?
My neighbors are coming outside at this point. My landlord is there. She's telling me to stay in the bathroom until the police arrive.
Okay. Let me ask you that. Your apartment.
Yeah.
Is there like a window or something? in the-
There's a window in my bathroom, so like, if you go up, because I have a townhome.
And you can see outside, is that correct?
Yeah.
Okay.
You can see the front of mine. The front lawn and all that.
And you said people were starting to come outside, correct?
Mhm.
And people were
Oh,
talking.
yes.
Yes,
Yes. And people were talking to you?
yes.
Okay. We don't,
Through the window.
we won't, that's fair. We won't talk about what they said necessarily, but you can see them, hear them
Yes.
clearly, you know who these people are, correct? Okay. And, the altercation that you guys had going on, was it very loud?
Yes.
Okay. Um. Okay, and so without getting into what they were telling you, what did happen next?
I'm sorry, what?
What happened next?
After,
After they started talking to you?
I'm just sitting in the bathroom waiting for the police to arrive at that point.
Okay, and while you're waiting for the police to come,
I'm sitting in the bathroom laying on the floor.
okay, do you know where Miss Jackson
She's
was?
trying to get into the bathroom.
Okay, so is she's
She's banging on the door, trying to break the door down.
still saying things to you at this point?
I mean, let me in the bathroom, you know what I'm saying? Want to kill you, I'm trying to harm you, I mean, in so many words.
Okay.
Not to say it like that, but when somebody's trying to kill you, I mean,
Fair. And at some point, are you aware that does she leave the scene?
she leaves the scene and police come in the house.
Okay, so the police come
Yes,
and she's still present in your house.
she's still part of the house.
Okay. And without telling us what you're hearing, can you hear them talking to her?
The police?
Yes.
No.
Okay. Can you hear anything while you're in the bathroom? Can you hear the police entering your apartment and anything like that?
Okay.
At any time,
Tammy's telling me, which is
What's-
my landlord,
what's going on?
what's
right?
going on as I'm in the bathroom.
Well, let me ask this. At some point, did you have contact with the police?
After they got her out.
Okay.
At this point, my phone's gone.
Okay. Well, let me ask you this. You're still in the bathroom. Were you able to see her being escorted out of your apartment?
I didn't see this.
Okay. But you do have contact with the police. is that
But I
correct?
do have contact with the police after they do remove her from my apartment.
And at that time, you tell them what happened.
Yes. I
Okay,
give them my report,
okay,
I talk to them, I give them my statement, they leave, they know she has my phone.
okay,
I had to have my boyfriend Jeff Core get a hold of her to take the phone, to get the phone back from her.
okay,
Because at this point, I can't, she won't give me my phone back.
okay. So at this point, officer leaves, she's gone. You believe she's still in possession of your phone, correct?
Yes.
And you do have contact with somebody who's, is it able to make
He
contact?
he made contact with her from my phone.
Okay.
And she's answering my phone.
What's that person's name again?
Jeffrey Core,
You can spell the last name.
Corri.
And this is at your request, correct? Okay.
Yes. Yes. Yes.
And are you able to get your phone back
Yeah,
after
she
this?
does retrieve my phone for me.
Okay.
She does give it to him. But I wasn't with him while he went to go get it from me.
Okay. Were you with him when he was able to make contact with her?
Yeah, he came to my house.
Okay.
Yeah.
So you could
So I could
hear her.
no, I didn't hear her on the phone.
Okay.
I called Jeff. Jeff came over to my house. Jeff said, okay, I just talked to Katina. I'm gonna go get your
Objection
phone."
hearsay.
You can't tell me what anyone else
Oh.
said.
Jeff should assist.
Okay. Well, at this point, he goes to get my phone.
Okay,
I don't know what they said.
okay. But he was at your house.
But he was at my house after she left to go get my phone.
Okay. And did he make contact with her using your phone in your presence? Were you in the, was he in your house? when
Was
did
he
that?
in my house when he was talking to her?
Yeah.
No.
Did he give that phone back to you?
Yes.
Okay. All right, and then is there anything happened after that? Okay. I just want to make sure that I have this correct. This incident with the knife takes place first, is that correct?
Takes place after we get into the physical altercation.
Okay. And
So we're fighting and then she grabs the knife.
Okay.
And then she's chasing me around my house with the knife.
okay,
And then I run up in the bathroom.
Okay.
That's when my neighbors call the police. The police get a hold of her. She has my phone. They get her out of my house. I go out of the bathroom. I give my statement. And then my boyfriend comes over to my house and then he goes to get the phone. from me.
okay. I think what I'm getting at here, is she's gone at this point, does she return to your home?
Later that night.
I just need you to clarify, what date was the date of the incident that the knife?
The 23rd. I don't. Yeah, I just know it was the 22nd or the 23rd.
Oh.
Because I mean, they run into the same day. This is the thing about this thing is January 23rd is when the altercation where we start fighting. Okay, then it ends on the 23rd with the night.
Okay.
So it's running into the same.
Taking,
It's like overnight.
It's like an overnight scenario.
thank you for clearing that up.
You're welcome.
All right, Aaron, I'm gonna show it to Mark as equals proposed exhibits 1, 2, 3, 4, and 5. For the time. Commissioner Proceedings.
Yes.
All right. Ms. Kirkpatrick, I'm gonna give you what's in Mark's will propose exhibits 1 to 5 without telling you what's in those photos. I want you to look through them and just tell me if you recognize them. And how do you recognize them?
Because it's my house and my body.
Okay. And You did you take any of those pictures? Okay. I'm gonna have you walk through each picture. Okay, I'm gonna ask you questions about each one. I want you to go to what's marked as people's proposed exhibit number 1. Okay. Can you tell me what's depicted in that, I think there's 2 photos on it.
Yeah, my hands with the scratch marks on them, and then the arm with my baby where she grabbed me.
Okay, let me ask you this. You were able to see those parts of your body after this altercation, is that correct? Okay. And, is it your recollection that you sustained those injuries during this altercation with Miss Jackson?
Yes.
And did you have either of those injuries prior to this altercation with Miss Jackson? So would you say those are a fair and accurate depiction of those parts of your body?
Yeah.
After this? Okay. Same thing with number 2. Can you please tell us what's in that photograph?
My arm.
Okay. Is there any injuries that are noticeable on your arm?
Yes, now I'm a bruise right here.
Okay, and is that also depicting an injury that you sustained during this altercation with Miss Jackson?
Correct, yes.
And was that injury present on your body in that location prior to the altercation with Miss Jackson?
No.
So would you say that's also a fair and accurate depiction of that part of your body? Okay. And also picture, what's been marked as people's proposed exhibit number 3?
Yep.
Can you describe what's in those photographs?
My kitchen with all the stuff everywhere that got knocked down and thrown around during the fight.
Okay.
In the altercation.
And,
This is my kitchen.
sorry. You indicated that, sorry, there are 2,
There's both of them,
Okay,
yeah.
okay, are they both of your kitchen?
Yes,
Okay, and you indicated that that was after this altercation took place?
yes.
Okay, and had your kitchen looked like that prior to this altercation with Ms.
No.
Jackson? Would you say that's a fair and accurate depiction of what your kitchen looked like after this altercation? Okay. Go to exhibit number 4. Can you tell us what's on that?
My living room.
So 1 picture, 2
Two.
pictures?
It's
2?
both, they're both pictures of my living room.
Okay, and are those also photographs that depict what your living room looked like as a result of this altercation?
Yes.
When did your living room look like that prior to this altercation?
No,
Okay, and would you say that that's an accurate depiction of what it looked like immediately following this altercation?
yeah.
Okay, and can you go to exhibit number 5, please? What's in exhibit number 5?
Another picture of my living room, my couch.
Okay.
So more of like. I mean, the other pictures were different areas of it.
Okay, so
Yeah, this is
all,
my living room.
so
This is
4
all-
4 and 5 of your
Five.
living room,
Yeah.
different area. Okay.
different areas.
And is that also what it looked like following this altercation with Miss Jackson?
Yeah.
Did it look like that prior to the altercation with Miss Jackson?
No.
Okay, and when you say it's a fair and accurate depiction of what it looked like immediately following this altercation?
Yes.
Your Honor, I would ask for the people's exhibits 1 through 5 to be admitted into evidence.
Any objection?
Without objection.
This is exhibit 1 through 5 are admitted.
Thank you. I didn't ask you about this, but we talked about a little bit. The photographs are of your living room or your kitchen. Would you say that that is the primary places in which this altercation took place minus
Yes.
the bathroom? Okay. There, you said that Ms. Jackson had started this altercation, but you were trying to defend yourself. Is that correct?
Yeah.
Okay. And during this time, you were afraid of what could happen.
Yes.
And when she left your house, were you still afraid of what could happen?
Yes.
Then I have no further questions at this time.
Cross exam.
Your Honor, thank you. Morning, Ms. Kirkpatrick. This is an apartment building where all this took place, is that right?
Right.
And you mentioned your landlord and said her name's Tam, is that correct?
Yes.
You know what her last name is?
Alvarado.
She's still your landlord?
Yes, yes.
And when you were speaking to her, was she outside the window with some of the other people, or was she
Yeah.
actually inside the apartment?
She was outside.
That's where you're describing, and there was other people outside of the window other than Cam, is that correct?
Correct.
You remember who they were?
They were my neighbors. I couldn't tell you the names of them.
Remember approximately how many there would have been?
4 or 5 of them, maybe. I'm not quite sure now. I can't give you a specific number.
And approximately what time is this incident in the bathroom that you were talking about?
I couldn't recall it at that time. I didn't have my phone.
You know, if it was,
It was during the day.
okay, so
I
like,
couldn't give you a specific time.
remember if it was morning or afternoon, evening?
Not recall.
Remember if it was daylight out?
I'm quite sure it was.
And other than you and Miss Jackson, was there anyone else in the apartment
No.
at that time? Okay. And you recognize the name Lauren Ford?
Yes.
Who is that?
My father.
He was not present during when any of this altercation was going on?
No.
And before all this started, you mentioned that you've been drinking, is that correct?
Correct.
Okay. What were you drinking?
I think we were drinking Amsterdam and Mike's Hard Lemonade.
What is Amsterdam?
It's vodka in Amsterdam.
And how much of that had you consumed?
I've had maybe about 1 or 2 drinks. What's I do?
When you say 1 or 2 drinks, were they shots or something else?
No, they were drinks like ice cups,
Okay.
like an ice cup.
And over what a period of time did you consume that alcohol?
Hours, like,
Yeah, minutes, hours.
can you repeat that?
Sure. The alcohol that you were talking about consuming, over what period of time had you been consuming that?
Like,
From start to finish, I guess.
I guess we started early morning, and then this altercation happened by after lunch around 3 or 4, so
Few
about
hours.
a few hours.
And on that day, had you taken any type of other substances that may have impacted your memory or able to perceive or recall things? You taken any type of psychotropic medications that day?
No, I'm not on any medication.
You had to take any pain medication that day?
No, sir.
The actual physical altercation you're talking about, where it was physical, you said that lasted for maybe about 5 minutes, is that right?
Yes.
And the knife that you were talking about, do you know based on your own personal knowledge whether or not that was retrieved by the police or seen by the
It
police?
wasn't retrieved or seen by them.
Go to the hospital after this incident,
I did not. They just took pictures and,
and by they you mean the police?
yes, sir.
This apartment that you live in, is that all on one floor? Or is there an upstairs to it?
There's an upstairs.
Is that where the bathroom was?
Yeah.
And what floor do you live on? Of your apartment
Upstairs.
building?
Upstairs.
Okay.
There's 2 bedrooms in the bathroom upstairs, and then the living room and the kitchen downstairs.
Apartment itself is like on the ground level, but the upstairs where the bathroom is above
Yeah, it's
that?
like a townhouse. It's a
Okay.
It's a townhouse. So it's not like a apartment.
Okay.
It's
understand.
a 2-story townhouse.
And so would have been looking out the window from the bathroom,
It was-
people that you would have been seeing would have been down below you? in other words?
Correct.
Okay.
Yes.
Did you tell any of them to call the police for you?
Yeah.
And prior to testifying here today, had you reviewed any police statements or any statements that you had given to the police?
No,
Other than maybe the prosecutor, have you spoken with anybody prior to court today about what you were going to be testifying to or saying?
no, sir.
Anyone specifically told you what to say here today in court?
No, sir.
He might tell you what not to say. At this point, when this was occurring, how long had you known Miss Jackson?
3 or 4 years.
And was it a usual or unusual occurrence for her to be at your house?
Usual. These are often.
Said you have a son that lives there, but he wasn't there at the time. Is that correct? Okay. Is that young son, teenager?
He's 6.
Where was he?
He's at school.
Mr. Ford that you mentioned, he does not live there.
No.
Thank you. Any redirect?
No, Your Honor.
Let's be excused.
Yes, Your Honor.
Actually, I have a question. Did any of these incidents take place on the 18th?
There are other incidents that did take place on the 18th. However, because they're assaults, they're misdemeanors, I am not going to
Okay.
answer questions about them because it's just gonna follow
Alright,
either way.
Sounds good. Just
Yeah.
wanted to make sure I was clear.
Yeah.
Okay, Ms. Kirkpatrick, you can be excused. You can call your next witness.
Your Honor, there are people that have no further witnesses.
Okay, will the defense be calling witnesses today?
We'll rely on the evidence presented, Your Honor. Thank you.
Okay, you can proceed to argument.
Your Honor, there was a little bit of confusion at the beginning there, but it does appear that we have been able to establish a little bit of a timeline for this incident. On or about the 22nd to the 23rd, there was a physical altercation that ensued between Miss Jackson and Miss Kirkpatrick, where that resulted in the defendant following or chasing the victim up her stairs in her townhome and saying things of the nature of "I'm going to kill you." The victim was scared for her safety, while being very afraid that she could be harmed with that night. She was able to get herself in the bathroom and lock the door. While she was in the bathroom with the door locked, the defendant was still actively trying to get in that room, pushing on the door, kicking on the door, or banging on the door, I'm sorry, saying things of nature of coming in the bathroom or saying things that led the victim to believe that, again, Miss Jackson was trying to harm her with that knife if she were to open the door. She does indicate that the police, at some point during this altercation, she had indicated she was going to call the police. Police do come to the location. It is indicated by the victim that she believes the neighbors had called because there was altercation was pretty loud. People could hear. People were telling her things through the window that lead her to this conclusion. Police do get there. They do. Miss Jackson is gone from the residence when the victim makes contact with the police. At that point, she realizes her phone is gone. She has a boyfriend, comes over to her house, is able to make contact with Miss Jackson to get the phone back. There's no indication that the boyfriend was there during the time of this altercation or was in possession of her phone. He is given the phone back by the defendant and was able to get the phone back to the victim. There's some other, again, the report indicates, or the complaint indicates there are other incidences that took place prior to this incident with Ms. Jackson. We didn't get into those because they're misdemeanors. However, I do think that there is more than sufficient basis for bind over on count 1, assault with a dangerous weapon. It's clear that Ms. Kirkpatrick was being chased with a knife. She did describe that knife as a carving knife. She did indicate that it did come from her set of kitchen knives. She was very much in fear of for her life and what could happen as a result of being harmed by that knife. And then there is count 2, interfering with electronic communication. The phone is gone. The phone is alleged to have been in Ms. Jackson's possession and is returned to the victim through a third party. I think that there's sufficient basis there to determine that Ms. Jackson could take that phone. Obviously, I talked to the victim previously. We talked about the 911 mention of calling 911. She did indicate that the phone was taken after that statement. I don't know how long, and I don't think there was a good way to flesh that out. So we're not going to be seeking to enhance like interfering with the crime report or anything like that. But I do ask that it be found over as charged on count 2 with just interfering with electronic communications. And of course, count 3 and count 4 just follow to circuit court. Thank you, Your Honor.
Mr. Austin.
Thank you, Your Honor. Recognizing, of course, that the standard at this stage is probable cause. It's very low burden, probably the lowest we have. Our court is the sole determiner of our ability at this stage. I think probably a lot of the issues were presented are likely to become issues of fact for a circuit court jury to sort through. I would just ask the court to keep that in mind when making its decision. I do think that the timeline and the testimony was rather, I think, jarbled and confusing. So I think there is probably likely a deficiency as it relates to count 2, I think. But I would oppose the bind over on all counts, and I would ask that the court not bind the matter over further proceedings.
As indicated by your attorney and Ms. Jackson, the burden is on the prosecution today, and it's a relatively low burden. It's a burden of probable cause, which requires more than mere suspicion that a crime was committed and probable cause that you were the defendant that committed the crime. We have testimony from one witness today. Her name is Zahaja Kirkpatrick. She described the incident taking place between the time frame of January 22nd, 23rd, in the area of 441 East Edgewood Boulevard, Apartment A, Lansing, Hingham County, State of Michigan. I would agree with Mr. Austin that some of the timeline was a bit confusing to follow. However, I find the testimony that was presented today, although difficult to follow, to be credible. The testimony was that they were at the house drinking, that a disagreement ensued and escalated. The alleged victim does not recall what, or at least didn't state what initiated the incident, but that it escalated to a physical altercation. She did indicate that the defendant, or the person she identified as the defendant, Ms. Katina Jackson, initiated the physical contact. She describes the relationship to be something similar to like a god-sister relationship, a blood relation, and that I believe she testified that the initial contact was her strike to maybe her arm. It was unclear as to what that initial contact was, but she did state the initial contact was made by Ms. Jackson, and that she was biting her and hitting, the defendant was biting and hitting the victim. The alleged victim tried to get the defendant off of her. She stated initially that she tried to call 911, but the defendant took her phone. I think as the testimony progressed, that timeline did get a little bit muddled as to when the phone or how the phone was taken, but I think that for the purposes of probable cause, we have sufficient information before the court as to count 2 interfering with electronic communications, as well as count 1 assault with a dangerous weapon, that being felonious assault, the dangerous weapon being what the alleged victim described as a carving knife from her kitchen set. She indicated that after the initial assault, the defendant chased her into the bathroom with a knife, stating things like, "I'm gonna kill you." And so the court is satisfied with the facts presented today for the purposes of probable cause. So count 1 and count 2 will be bound over to the circuit court. Count 3, which is a misdemeanor assault and battery. Count 4, which is another misdemeanor assault and battery, will accompany both count 1 and 2. Bind over date's going to be June 1st. You do not need to appear in court on June 1st, ma'am. God bless you. Sorry. You're fine. You do not need to appear in court on June 1st. That's the date they get the file from this court, unless Mr. Austin provides the circuit court with a reason why you need to have another arraignment at the circuit court level. That arraignment will be waived. Your next court date in circuit court will then be your pretrial. They'll notify Mr. Austin of that date, okay?
Yes, ma'am.
Do you have any questions today?
Yes, ma'am, I do.
Yes. Well, questions for the court, because you may have questions that may be,
For the court.
okay,
I just would like to know what the punishment of perjury is.
the penalty of perjury, you mean?
Yeah.
Well, there, it depends on, are you asking in relation to what the witness testified?
Yes.
Okay, that sounds like a question for your attorney.
Okay, I wasn't sure. That's why I
Okay.
asked.
Okay, yeah, and it sounds like you're making an allegation that there was perjury. That's for you and your attorney to discuss as part of your defense at circuit court, okay? Okay. The court has no information to the contrary of which she stated here today, and the court found her testimony to be credible today. And so you and your attorney can work through your potential defense for the circuit court, okay, ma'am?
Yes, ma'am.
Do you have any questions for the court?
I do not. I better understand now.
Okay, very good. Your bond was set at 5,000 personal recognizance. There is a no contact order in place that will continue. Any additional matters to the record?
No, Your Honor.
Nothing further on Ms. Jackson, Your Honor. Thank
Thank you. You're all set, Ms. Jackson. And Ms. Lacy, here's your exhibit.
Thank you.
you. Thank you, Judge.
Thank you.